First of all, I'm honored to have the opportunity to speak to you today and present the results of my research. The topic of my speech will be the European Supervision Order as a non-custodial alternative to the European Arrest Warrant in the context of effectiveness and guarantees of international cooperation in criminal matters and criminal proceedings. My presentation will focus on the following points. The entry point of my presentation will be to introduce the European system of preventive measures available to the judicial authorities of the member states at pretrial stage of criminal proceedings. Next, I will describe the definition of effectiveness, especially for the context of international cooperation between EU member states and criminal procedure. The next point will be a presentation of the European Arrest Warrant and its revolutionary impact on the international cooperation. It will also consider the weakness and threats that have arisen over the years in the functioning of this measure. And finally, I will present a much newer non-custodial measure of international cooperation, the European Supervision Order, and I will try to answer the question, can using the European Supervision Order as an alternative solve the European Arrest Warrant problem and ensure better standard of realization of fundamental rights. Moving to the first point, the European system of preventive measure consists of two core measures of international cooperation between EU member states. These are the European Arrest Warrant established by the framework decision of 13 June 2002, which became functional in almost every EU countries from 2005. The secondary measure is European Supervision Order, established by the framework decision of 23 November 2009 on application between member states of the European Union of principle of mutual recognition to decision on supervision measure as an alternative to provisional detention. In following presentation, the functioning of the system will be analyzed from the point of view effectiveness and guarantees of fundamental rights. In the beginning, it is necessary, of course, to describe that what is effectiveness. According to the dictionary, effectiveness is the fact of producing the results that is wanted or intended, the fact of producing a successful results. In addition, it is also necessary to distinguish the term from the closely related expressions such as efficacy and efficiency, which put another sense of another elements. This distinguishing element of the effectiveness is not only the fact that the main goal is achieved, but also the secondary goals and some kind of right way to achieve them. But how does effectiveness relate to the law, criminal proceedings, or international cooperation? Above all, effectiveness is considered as basic parameters for evaluating the functioning of law. In the criminal proceedings, effectiveness is not clearly defined and is often confused with efficiency. Of course, the fundamental element of the effectiveness is the achievement of the primary objective of the proceedings to detect and punish crimes. The doctrine states that the main purpose of the procedure is to determine whether a criminal offense has been committed, determine the perpetrator, and prosecute that person. In the Polish criminal procedure, Article 2 states that the purpose of this code is to establish a rule which will secure that the perpetrator of a criminal offense shall be detected and called to the penal responsibility. Besides giving expression to the universal objectives, this provision says that one of the objectives of criminal proceedings is to prevent an innocent person from being an responsibility, and to ensure that proper use is made of all legal measures provided in the statute. In addition, due to the specific role of criminal proceedings in the whole judicial system, it is necessary to realize certain guarantees and axiological values in addition to achieving the main goal, and to get overall effectiveness. Only the achievement of the intended purpose in the intended way sufficiently fulfill the purpose of the criminal process, and only this way the proceedings can be considered as effective. Moving to the European arrest warrant, this measure was the biggest revolution for the international cooperation in criminal matters. It established a simplified extradition mechanism between EU member states. It was based on the principle of mutual recognition and the principle of mutual trust. The framework decision set out strict limits, only 15 days with consent and 60 days without consent, which replaced the standard extradition, which takes up to 6 months of average. The measure was based on the direct cooperation between judicial authorities, eliminating completely political and diplomatic factor. The principle expressed in the framework decision was that the order should always be enforced unless there were strict mandatory or optional grounds to refuse. In addition, the application of the European arrest warrant no longer required verification of dual criminality. The only requirement is that it be punishable by maximum period of at least 3 years of imprisonment in the issuing state. And EU countries can no longer refuse to surrender their own nationals unless they take over the execution of the prison sentence of the wanted person or the proceedings against this person at the pre-trial stage, which made it effective to prosecute those that try to hide from the responsibility in the country of their origin. Looking at the statistic of the European arrest warrant, it is apparently that the measure has become widely used, particularly in Poland as the issuing state, which we are the leader between 2005 and 2011. However, Germany was the leader as the European arrest receiver state. Between 2005 and 2020, total more than 280 warrants were issued. Undeniably, the European arrest warrant as the first measure of international cooperation in criminal matter has become a great success and resulted in much more effective international cooperation in criminal matters. However, despite the measure's many advantages, there have also been some disadvantages and threats, especially in recent years. One of the risks related to the European arrest warrant is the problem of overuse of pre-trial detention. Above all, the problem has general dimension in most EU countries. The EU institutions already noted in the first decade of 21st century that the problem should be treated as a serious threat to fundamental rights. For example, it was mentioned in the Hague program in 2005 and in Stockholm program in 2009 and in many other documents of EU policy. Statistics shows that 1 in 5 people in prison is pre-trial detained, and total number of these people is over 100,000. Of course, the widespread of use and the success of European arrest warrant is a kind of part of this problem, and exacerbate the problem overall. Due to the fact that many countries apply the same or very similar condition for pretrial detention on the ground of European arrest warrant as for the domestic proceedings, a person whom a warrant has been issued almost always fulfill this condition. This person often have no nationality or residence in the country in which they were detained, and even if they have the court of the member state executing the European arrest warrant almost always using pretrial detention for the duration of surrender of the wanted person. It was due to the lack of the residency in the country of the or the fact of previous exercise of freedom of movement in the EU territory. It was seen by the court as an attempt to hide from justice, which results in the use of pretrial detention. The practice results in the situation of persons of another nationalities and non-residents being sufficiently worse than and the realization of their fundamental rights being threatened. It should be noted that judicial authorities always are obliged to apply protective measures proportionally and apply the principle of minimalization of preventive measures. Violation of this principle means that even if international cooperation is effective, a criminal trial during which fundamental rights were violated cannot be considered as effective because the way to achieve the final goal was wrong. Unfortunately, there's no actual statistic in EU states how many people are pretrial detained on the ground of European arrest warrant or after its surrender to the country of issuing the warrant. However, the German statistics show that as many as 60% of pretrial detained people are foreigners, which show a certain correlation that is relevant to the practice of the European arrest warrant. Turning to the other problem of the European arrest warrant, which has become a serious problem for the effectiveness of the criminal proceedings and international cooperation. It was the trend are grounded for the grounds for refusal European arrest warrant were not expressed in the framing decision. Two new bases can be identified: condition of the imprisonment detention below the standard of the fundamental rights, and the called of the rule of law crisis. This is the lack of independence of the judicial system. Moving to the first of the threats pointed out, a refusal of European arrest warrant on the ground of violation of fundamental rights under Article 4 of Charter or the Article 3 of Convention. Example of the application of this grant were cases where the Republic of Ireland refused to surrender a person to the basis of European arrest warrant issued by Greece or Lithuania. And the grounds have been confined in judgment of European Court of Justice of EU. The basis for the refusal was the risk that the fundamental rights of this person would be violated in the prison of this country due to the condition below the European standard of Article 3 or 4. Refusal of warrant is such a circumstances had the effect of completely paralyzing criminal proceedings against this person. The suspect was gained that kind of immunity until she or he remains in the country of refusal. The only way for such a person to be held responsibility was for the country of resigning the European arrest to take over the prosecution against this person, which was not always possible because of a difference between legislation, or sometimes this country don't want to prosecute this person. The second threat mentioned is the refusal of European arrest warrant due to the so-called rule of law crisis. This ground is also not expressed in the framework decision. It is based on the risk of violation of fundamental rights through a lack of independence of the judicial system in the member states issuing the European arrest warrant. That is violation of Article 47. The grounds have been formed in the judgments of the European Court of Justice. The current standard for refusing European arrest warrant on this ground is expressed in the case of ruling on the preliminary question of Dutch court, and this is the case called ML test, because this case described the test how to check is the country suing the European arrest warrant have the risk of violation of the fundamental rights. According to this ruling, the court must verify each time if it wants to refuse a European arrest warrant that there is a systematic threat to independence of the judicial system and whether it affects the case in the question. The court must find that the circumstances are such as to create a high risk of violation of the fundamental rights under Article 47. Also on this ground, criminal proceedings in the country issuing the warrant are paralyzed and completely ineffective. The success of European arrest warrant based on the principle of mutual recognition and noted problem of overuse of pretrial detention formed the grounds for a new non-custodial measure of international cooperation. The European supervision order was also based on the principle of mutual recognition, but preventive measures other than pretrial detention. Establish the possibility of applying the non-custodial measures, supervision measures, on the suspect in order to guarantee the effectiveness of the criminal process. Mutual recognition of the measure ordered under the framework decision was based on the domestic law of the residing state. Therefore, only measure that exists in the country, in the residing country, can be used. In case where such a measure does not exist or is significantly more onerous, it is possible only to adjust or refuse the order. The purpose of establishing the measure was to enhance the right to liberty and presumption of innocence in the European Union, the protection of community, and higher standard for the realization of fundamental rights. Unfortunately, the European Supervision Order is currently not widely used, despite its introduction more than 10 years ago. The new measure has met with opposition from some member states, and some countries have only implemented it in 2019, for example, Republic of Ireland. However, returning to the problem of the European arrest warrant outlined earlier, there is a question should be asked whether using the newer measure of European Supervision Order can, as an alternative, can solve the European arrest warrant problem? The answer to this question needs to be broken down into the three problems described. Firstly, in the case of the problem of excessive or overuse of pretrial detention, obviously the European Supervision Order will not solve the whole problem overly, because the European arrest warrant is only a fraction of the general problem, but undoubtedly allows the authorities to resign of European arrest warrant in order to ensure that the criminal proceedings proceeds. The new measure allow to use other measure that meet the proportionality and minimalization requirements, and it will be possible to guarantee a higher standard of respect for human fundamental rights without compromising effectiveness. There will be an equal level of realization of the rights of the suspects, regardless of their nationality, residence, or exercise of their freedom of movement on the EU territory. It will also be possible to avoid unnecessary pretrial detention of persons who intend to cooperate with law enforcement without forcing this person to relocate to the country where these proceedings are taking place. Secondly, in the case of problem of refusal of surrender on both grounds, the use of European Supervision Order offers the possibility to conduct effective criminal proceedings, which would be paralyzed if the European arrest warrant were issued and refused. In the case of the problem of refusal on the ground of the condition of pretrial detention, the use of the European Supervision Order does not result in the person being surrendered to the requesting state, and also not it is not pretrial detained. Therefore, his or her rights under Article 4 or Article 3 of the Convention cannot be violated. The issuing state also has time to adjust the standard of detention in prisons or prove that a sufficient standard is being applied in order for subsequently issue European arrest warrant in the future. In contrast, in the context of refusal on the grounds of risk of violation of fundamental rights under Article 747, the case is more complicated. In the case of such a ground, the court finds that the judicial system in the issuing state does not meet the standard, and there may be violation of the rights to the fair trial. This means that the execution of the measure requested by the authorities, which are not independent, may result in violation of rights, even in duration of the executing the European Supervision Order. It should be noted, however, that the seriousness and severity of the measure applied difference significantly. So the control and control on violation threshold should be adjusted. The application of the European Supervision Order leaves open the possibility of kind of control of the proceedings by the states where there are doubts about the independence of the authorities. Furthermore, the person is not surrendered to the state as is not under the direct control of this country. The risk of violation in such a situation is significantly reduced, and issuing state possibly receive time to adapt their system of judicial authorities or prove that the actual system functioning properly, as well as time for the residing state to eventually take over the prosecution against this person. Generally, in conclusion, the use of European supervision order may have positive impact on the effectiveness of proceedings by ensuring a higher standard of respect for fundamental rights, and may minimize the discussed European arrest warrant problem, and also may replace the European arrest warrant in the situation of refusal or the threat of the refusal. Thank you for your attention.